As we all know, on Thursday, Secretary Bellows, a Democrat, issued a ruling disqualifying former President Donald Trump from being on the Republican primary ballot in Maine. Her reason, his alleged involvement in connection to the January 6th Capitol riots in 2021. Maine became the second state in the nation to bar Mr. Trump. However, the courts here will make the final ruling. Secretary Bellows is drawing praise and criticism from state politicians on both sides of the aisle. Our Donovan Lynch has more on the debate and its legal grounding.
In Maine, a question of law with national consequence.
Does 14.3 apply to presidents? We don't know for sure.
This week, Secretary of State Bellows barred former President Donald Trump from Maine's Republican primary ballot, saying his actions in the January 6th riot disqualify him from the presidency. Her argument is rooted in Section 3 of the 14th Amendment to the U.S. Constitution, which blocks insurrectionists from holding public office.
My sole obligation is to the Constitution and the rule of law.
Now, this decision is drawing criticism from Republican leaders who see the Secretary of State as carrying out a partisan agenda.
Get rid of Bellows for this incredibly political move.
Republican State Representative Mike Sobolewski, who's joining the call to impeach Secretary Bellows, argues that because former President Trump was never convicted of insurrection in a criminal court, it's wrong to exclude him from the ballot without a trial.
This is about the Fifth Amendment and his constitutional right to a due process. The president's never been convicted of that.
The wording of the Constitution Bellows uses to justify disqualifying Trump from the ballot specifies that somebody must have, quote, engaged in insurrection to be removed from office. To legal scholar Dimitri Baum, that might not fall on a jury to decide.
And generally speaking, constitutional provisions don't require a finding of criminal liability.
For supporters of Bellows, like Democratic State Senator Joe Baldacci of Bangor, barring Trump from the primary ticket is a just punishment for allegedly supporting an attempt to overthrow the government after the 2020 election.
This is a democracy, and we're not going to allow people who violate the rules benefit.
As more states consider Mr. Trump's standing on primary ballots, the U.S. Supreme Court will likely weigh in on a constitutional question that has few examples to lean on.
There's not a lot of law, a lot of precedent to really look at and parse through in deciding which approach is the better one.
Leaving uncertainty before Election Day. Donovan Lynch, News Center, Maine.
Again, it is important to note Secretary Bellows has suspended the effect of her ruling until a superior court rules on any appeal or the time to appeal has expired. A spokesperson for the Trump campaign released a statement following the decision saying it does plan to appeal.